everybody. This is Advocate Lucinda, your empowerment lawyer. Someone wrote me and asked, when are you going to do part 2 pretext? Well, as I promised today, we are going to discuss pretext for retaliation. So let's get started. There may be some of you who want to go back and review part 1, pretext for discrimination. So here you can click the link below and review. Pretext is when an employer articulates a reason for the adverse action he or she took against the employee. But it's not really true, but it is a cover-up for the action. In this case, pretext for retaliation. So what we've done here is put discrimination and retaliation side by side so that this distinction can be made more clearly. So for the purposes of this video, let's use age as the protected class member. Okay? So to make out a prima facie case of discrimination, the plaintiff needs to show that he or she is a member of the protected class. Age is what we're using. 2, the job performance must be met at the time of the adverse action. Okay? 3, the plaintiff must have suffered an adverse employment action, termination write-up, for example. And 4, you need to show some disparate treatment or differential treatment that another similarly situated individual who was not in the protected class was treated more favorably. Someone who is younger, for example. Check out McDonnell Douglas Court versus Green. It is an excellent case on discrimination, particularly indirect discrimination or circumstantial evidence. Okay, check that out. It's at 411 U.S. 792. It's a 1973 case, a model case for discrimination. Now, retaliation, on the other hand, the prima facie case to prove retaliation, you must show that the employee is engaged in statutorily protected activity. There must be some statute. For example, the First Amendment gives individuals the right to speak out against activity that is violating their rights. 2, the plaintiff must have been subjected to adverse employment action, written up, terminated. There are other adverse actions included in those 2 examples. 3, the employer's actions must be motivated by the protected activity. Now, do you see a difference there? There is a major difference there in discrimination and retaliation in terms of the prima facie showing. Does anyone see that? I'll give you a minute. Okay, time's up. Retaliation is different from discrimination in that it doesn't matter whether the underlying conduct that the employee complained about, age discrimination, was actually discriminatory. Now, this is key. What are we saying? We are saying that it's sufficient that the employee reasonably believed in good faith that she or he opposed a practice that violated Title VII. In this case, age discrimination. Okay? Is that clear now? Check out Pickett versus Sheridan Healthcare Center, a case that will help you to better understand this point. You can find that at 610 Federal 3rd 434. Now, the employee must present evidence. 1. Secondly, that evidence must strongly demonstrate that the employee honestly believed that the action taken against him or her was based on pretext for retaliation. Now, I have said in previous videos multiple times that a litigant cannot expect to go into a lawsuit and not be prepared to conduct discovery. That's how you get your evidence. And we've gone over depositions, admissions, interrogatories, production of documents. Those are the tools that attorneys mostly use to acquire the evidence they need to make out their client's case. Or an individual suing pro se has the same responsibility. Now, the difference between the depositions, admissions, interrogatories, and production of documents, the litigant can automatically request that the opposing party participate or respond to their discovery request. Subpoenas and open records are applicable in a case where the parties that the litigant is attempting to obtain information from, they are not part of the lawsuit. And so thus, you would use these two tools to obtain information from those parties. But evidence, you have to get your evidence, and you cannot be shy about it or timid about it. This is the heart of every litigation. Another important point is that evidence that supports a claim for pretext for discrimination can also be used to support pretext for a retaliation claim. Remember that. To more fully demonstrate pretext for retaliation, let's look at some scenarios. Well, let's say that the employee worked for the employer for 10 years. And let's say that she had a stellar record, never been disciplined, never had a write-up, never been late to work. And she complains that she was discriminated against, not just herself, but other employees, because they were older, because of their age. And after she complains, she gets a write-up. Well, on its face, this is strongly evidence of pretext for retaliation. I don't even know at this point what articulation the employer would give, but just on its face alone, given the employee's background and her commitment and good work record, it raises a flag of retaliation, pretext for retaliation. I was the attorney for an individual who filed a Title VII age discrimination case. And out of the discovery, I learned about so much hostility against my client, pure animosity They cursed at her. Literally, I couldn't believe the level of animosity that they had against my client. They hurled insults at her, literally cursed her out using the 4-letter word. It just blew my mind. But these things happened after she complained about age discrimination. And oddly, not only did her superior show animosity towards her, but her coworkers who were under or who were supervised by the same superior. So that takes us into another area that we will discuss later on, whether an employer has a responsibility for its supervisor who is engaged in retaliation. But animosity, sometimes it comes in the form of emails, texts, and sometimes it literally happens in person, as it did in this case. At the heart of a retaliation case is the question of genuineness, whether a reasonable or rational juror would question the genuineness of the employer's articulation for the adverse action. And let me give you an example. The employer articulated that the adverse action they took against the employee, who, by the way, filed an age discrimination case, the employer alleged he threatened one of the managers. At the deposition, I deposed the manager, or this person is in a managerial position, and asked whether the employee threatened him. He was adamant that the employee did not threaten him, and not only that, he testified he never felt threatened by the employee. And secondly, he produced his statement in the deposition and a written statement where he asked the company to give the employee his job back because his termination was not justified. You see? Now, would a rational juror or jury believe the employer's articulation? These are things that you need to look out for. When you're dealing with age discrimination cases, you're often faced with ambiguous behavior by the employer. After the employee complains, for example, the employer engages in a conversation with the employee where he or she uses terms such as dead wood or slow as molasses or dinosaurs. Never used those terms before. So one would need to look at those terms, look at the overall picture, and it may very well be pretext for retaliation. And also check out my new channel, Judicial Justice. Judicial Justice addresses accountability. Accountability for judges, accountability, yes, for attorneys, accountability for officers of the court. It also provides you with some tips on courtroom and court etiquette. And of course, it advises you of your rights. So check it out. It will be helpful to you in your quest for justice. Until we meet again, this is Advocate Lucinda, your empowerment lawyer. Be empowered.